Namaste and welcome to Daily News Simplified, the what, why, and how of newspaper reading. Today, we would be analyzing the Delhi edition of the Hindu newspaper of 2nd April 2018. Now, let us begin. Now, we have taken this article from page 2. Now, the reason this article is in the news is because a trial run of solar powered boats is being conducted at the Chilika lake. Now, the reason it is being conducted is to reduce noise pollution. Now, this is because around 14,000 boats sail on the Chilika Lake, and because of their diesel powered engines, they make a lot of noise, which has taken a toll on the migratory birds and the Iradway dolphins that are present in the Chilika Lake. So, an initiative is being undertaken to move beyond diesel powered engines to solar powered boats. Now, Chilika Lake is important for your upcoming prelims examination. So, let us understand the basic features of Chilika Lake. But before that, let us see as to where it is placed in your UPSC syllabus. Now, in your UPSC prelims syllabus, Chilika Lake would be placed in Indian geography under the subsection Physical Geography of India. Now, let us understand the basic features of the Chilika Lake. Now, Chilika Lake comprises of three different ecosystems, which are marine, brackish, and freshwater ecosystem. Wherein here the term brackish means slightly salty. Apart from this, Chilika Lake is also a shallow lagoon. Now, a lagoon is a body of water which is separated from a larger body of water such as the sea by a narrow strip. Now, the location of Chilika Lake is that it is located in the state of Odisha, and in particular the district of Puri, Khurda, and Ganjam. Apart from this, Chilika Lake also has islands within it, but one of the main island is Nalaban Island, which is located here in the map. Now, this Nalaban Island is notified as a bird sanctuary under the Wildlife Protection Act of 1972. Now, the in-source rivers of Chilika Lake is made up of roughly 52 rivers and small rivulets, such as the Daya River. Now, the Chilika Lake is the largest lagoon in India. Now, as you know, lagoon is a body of water which is separated from a larger body of water, such as the sea, by a narrow strip. And as you can see here, Chilika Lake is separated from the Bay of Bengal by a narrow strip, as shown here in the map. Now, apart from this, Chilika Lake is the largest wintering ground for migratory waterfowl in the Indian subcontinent. Now, these migratory birds are also protected under the Wildlife Protection Act of 1972. Now, Chilika Lake is also a designated Ramsar site, which means Chilika Lake is a wetland of international importance. Now, apart from this, Chilika Lake was also included in the Montreux record in 1993. Now, the Montreux record is maintained as part of the Ramsar list, and in general terms, it means those wetlands of international importance which are threatened. Chilika Lake was removed from the Montreux record in 2002 and became the first site in Asia due to the successful restoration done by the Chilika Development Authority. Now, hopefully, up till here, you have understood that Chilika Lake comprises of marine, brackish, and freshwater ecosystem, and that apart from this, Chilika Lake is also a shallow lagoon, meaning that Chilika Lake is a body of water which is separated from the larger body of water, which in this case is the Bay of Bengal, by a narrow strip, and that the Chilika Lake is located in Odisha, and in particular the district of Puri, Khurda, and Ganjam. Moreover, you also understand that one of the main islands in Chilika Lake, called Nalaban Island, is also a designated bird sanctuary under the Wildlife Protection Act of 1972. In addition, Chilika Lake is the largest lagoon in India and is also one of the largest wintering grounds for migratory waterfowl in the Indian subcontinent. And these migratory birds which flock to the Chilika Lake are also protected under the Wildlife Protection Act of 1972. Apart from this, Chilika Lake is also a designated Ramsar site, which means it is a wetland of international importance and was also briefly placed in the Montreux record as a threatened wetland of international importance. But due to the successful restoration done by the Chilika Development Board, it became the first site in Asia to be removed from the Montreux record in 2002. Now, all these facts and features becomes important from the perspective of your upcoming UPSC prelims examination. Now, with this, we move on to the next article. Now, we have taken this article from page 1. Now, the reason this article is in the news because the Central Vigilance Commission has urged the Prime Minister's office to bring private sector ban within the purview of the Central Vigilance Commission. Now, as of now, vigilance officers in all state owned public sector banks are required to report irregularities and any wrongdoing or any issue of corruption to the Central Vigilance Commission. Now, hopefully, up till here, you've understood as to why this article is in the news. That the Central Vigilance Commission has asked the Prime Minister's office to bring private sector banks under the purview of the CVC. Now, currently, public sector banks report issues of corruption to the Central Vigilance Commission. Now, this news is in transition, so we have to wait for the reply of the Prime Minister's office. Now, moving forward, what we'll do is understand the Central Vigilance Commission from your upcoming prelims examination perspective. Now, the CVC was set up by the Government of India in 1964, and this was done on the recommendation of the Santhanam Committee. However, through the Central Vigilance Commission Act of 2003, CVC became a statutory body. Now, statutory body is a non-constitutional body which has been created by an Act of Parliament. Now, hopefully, up till here, you have understood that the CVC was set up by the Government of India in 1964 based upon the recommendations of the Committee on Prevention of Corruption, which was headed by K. Santhanam. And moreover, the Central Vigilance Act of 2003 made CVC a statutory body. Now, let us understand the aim of the Act. Now, CVC is conceived as the apex vigilance institution and is free of control from any executive authority. Now, the CVC can conduct inquiries into offences that have been made under the Prevention of Corruption Act of 1988, and this inquiry can be conducted against certain categories of public servants of the central government, corporations established by or any under Central Act, government companies, societies, local authorities that are owned or controlled by the central government. Apart from this, CVC also exercises superintendence over the Delhi police establishment. Now, the CVC also advises various authorities in central government with regards to their vigilance work. Now, hopefully, up till here, you have understood the aim of the Central Vigilance Act of 2003. That under this act, the CVC is the apex vigilance institution. That it can also conduct inquiries into offences under the Prevention of Corruption Act of 1998, and this inquiry can be held against certain categories of public servants of central government, corporations established by or under Central Act, government companies, government societies, local authorities owned or controlled by the central government, and the Delhi police establishment. Apart from this, the CVC also advises central government authorities on vigilance work. Now, apart from this, let us understand other basic features of the CVC with regards to your prelims examination perspective. Now, the Chief Vigilance Commission would consist of 3 members, which are the Chief Vigilance Commissioner, who would be the chairperson, apart from 2 other Vigilance Commissioners. Now, the Central Vigilance Commissioner and other Vigilance Commissioners shall be appointed by the President based on the recommendation of a committee consisting of the Prime Minister, Minister of Home Affairs, and Leader of the Opposition of Lok Sabha. Apart from this, the Chief Vigilance Commissioner, any other Vigilance Commissioner, may resign to the President of India, and similarly may also be removed from office by the President of India. Now, hopefully, up till here, you have understood basic statements with regards to the Chief Vigilance Commission that are important from the perspective of your upcoming prelims examination. That the Chief Vigilance Commission would consist of members as Chief Vigilance Commissioner, who shall be a chairperson, and not more than 2 Vigilance Commissioner as members. Moreover, the Chief Vigilance Commissioner and other Vigilance Commissioners shall be appointed by the President of India, which would be based on the recommendation of the committee that consists of the Prime Minister of India as chairperson and the Minister of Home Affairs and the Leader of Opposition of Lok Sabha as other members. Moreover, the Chief Vigilance Commissioner or any other Vigilance Commissioner may resign or can be removed by the President of India. So now with this, we move on to the next article. Now we have taken this article from the editorial page on page 8. Now what this article talks about is that the central government has planned to divest 76% of its stake in Air India. Now the government is offering a majority stake in Air India and Air India Express with management control. Now, to understand this, you should know a difference between disinvestment and privatization. Now, privatization implies a change in ownership, thereby resulting in a change in management. But disinvestment does not always imply a change in management. wherein disinvestment is a dilution of the stake of the government. And if the dilution is such where the government has less than 50%, then the government retains management. But if the dilution is more than 50%, then there is a transfer of ownership and management. And this would be called privatization. Thus, the scope of disinvestment is wider than privatization. Now, hopefully, up till here, you have understood that the government of India would be divesting 70% of its stake in Air India, whereby offering majority stake in Air India and Air India Express with management control. Now, for basic conceptual understanding, the difference between disinvestment and privatization, wherein privatization implies change in ownership, which would result in change in management, while disinvestment does not always imply change in management, wherein dilution in stake of government, if less than 50%, the government retains management. But if the dilution in stake of government in a public enterprise is more than 50%, such as in Air India, then there is transfer of ownership and management, and this is called privatization. Therefore, the scope of disinvestment is wider than the scope of privatization. Now, apart from this, some of the subsidiaries of Air India, such as Hotel Corporation of India, Air India Air Transport Services, Air India Engineering Services, among others, are not being sold. Instead, they're being transferred to a special purpose entity. Now, a special purpose entity is a legal entity created to fulfill narrow, specific, or temporary objectives. And these special purpose entities are typically used by companies to isolate the firm from financial risk. Now, hopefully, up till here, you have also understood that the Air India subsidiaries, such as Hotel Corporation of India, among others, are not being sold, but they are being transferred to a special purpose entity. Now, apart from this, the Government of India is pursuing this policy because in the year 2016 to 17, Air India suffered a net loss of more than 5,700 crore and has been suffering from poor management and operational inefficiencies. Now, questions on issues related to Indian public enterprises or public sector enterprises have been previously asked in your UPSC mains examination, and in particularly to privatization of some of India's public enterprises. And in similar terms, this article and the explanation given in this section becomes relevant within that aspect. So now with this, we move on to the next article. Now we have taken the lead editorial from page 8. Now this article mentions about the selection and removal of judges of High Court and Supreme Court. And as per this lead editorial, members of the judiciary are involved in the selection procedure of the judges through the collegium system. However, no such judicial members are involved in the removal process. So what we'll do with regards to this article is first understand the procedure of selection of judges of Supreme Court and High Court and the removal of judges. So within this context, let us understand about Article 124, the first, second and third judges cases, National Judicial Appointment Commission, and the procedure to impeach a judge. So let us first understand about Article 124. Now, judges of the High Court and Supreme Court are appointed by the President of India. However, the method and procedure of selection has not been clearly provided in the Constitution. So the process for selection, elevation and transfer of judges to higher judiciary has been a debatable issue due to the overlapping nature of the legislature, executive and the judiciary. Now to understand the complete procedure for the selection of judges, let us first understand about the three judges case. Now in the first judges case, which occurred in 1982 in the SP Gupta vs Union of India case, the Supreme Court held that the opinion of the Chief Justice of India and the Chief Justice of respective high courts was merely consultative in nature, and therefore the power of selection resides solely and exclusively with the central government, wherein the central government could override the opinion given by the judges. But however, in the second judges case, which occurred in 1993 in the SC Advocates on Records Association vs Union of India case, the Supreme Court emphasized that the government does not enjoy primacy or absolute discretion in selection of Supreme Court judges. And similarly, in the third judge's case, the ruling in the second judge's case was further elaborated and articulated by another 9-judge bench, which is effectively known as the third judge's case. And this case effectively laid down the principle of the collegium system. Now, hopefully, up till here, you have understood that the judges of the High Court and Supreme Court are appointed by the President of India. But however, the method and procedure of selection of judges is not clearly provided in the Constitution. So, in the first judges case, in 1982, in the S.P. Gupta versus Union of India case, the Supreme Court held that the opinion of the Chief Justice of India and the Chief Justice of the High Court is consultative in nature, and therefore the power of selection resides solely and exclusively with the central government, and the central government could override the opinion given by the judges, thereby effectively allowing executive to have primacy in the selection of judges. But in the second judge's case, in the Supreme Court Advocates on Record Association versus Union of India case, the Supreme Court held that the government does not enjoy primacy or discretion in matters of selection of Supreme Court judges. And lastly, in the third judge's case, the Supreme Court further elaborated and articulated upon the second judge's case and effectively laid down the principles of the collegium system for the selection of judges. Now let us understand as to what is the collegium system. Now the collegium system is a forum of the Chief Justice of India and the four senior most judges of the Supreme Court. And this forum recommends selection and transfer of judges. So the collegium system effectively brought the primacy of the judiciary or the judicial members in the selection of judges. But the Government of India passed the Constitution 121st Amendment Bill of 2014 to establish the National Judicial Appointment Commission. And this commission would effectively replace the collegium system. The Supreme Court of India declared the NJAC as unconstitutional. Now, the Supreme Court declared the NJAC as unconstitutional because it observed that it was interference from the executive in judicial appointment. And thereby, the Supreme Court, through this verdict, effectively revived the collegium system. Now, hopefully, up till here, you have understood that the collegium system would consist of a forum of the Chief Justice of India and the four senior most judges of the Supreme Court. And this collegium would recommend the selection and transfer of judges. However, the Government of India, in its 121st Amendment Bill of 2014, formed the National Judicial Appointment Commission, which would have effectively replaced the collegium system. But the Supreme Court declared the National Judicial Appointment Commission as unconstitutional because it observed that it was interference of the executive in judicial appointment and thereby reviving the collegium system. Now, hopefully, up till here, you have understood the procedures and method of selection of judges. Now, apart from this, what this article talks about is the impeachment procedure for the Chief Justice of India. Now, judges of the Supreme Court shall be removed under Article 124, Clause 4, which also includes the Chief Justice of India. Now, apart from this, judges of the High Court are also removed in the same manner as that of a judge of a Supreme Court under Article 2017, Clause 1, Subclause B. So, let us understand the impeachment procedure or the removal procedure of the judge of a Supreme Court under Article 124, Clause 4, through which you would be able to understand on how a judge of the Supreme Court is removed, on how the Chief Justice of India is removed, or how any judge of the High Court or the Chief Justice of any High Court is also removed. And we would try to understand this with the help of the Constitution of India itself. Now, the impeachment procedure for a High Court judge has been provided under Article 2017, Part 1, Part B. Now, it states that a judge may be removed from his office by the President of India in the manner as for the removal of a judge of a Supreme Court, which is given under Article 124, Part 4. So, hopefully, up till here, you have understood that under which article does the impeachment of a High Court judge falls. Now, let us understand about Article 124, Clause 4. Now, Article 124, Part 4 gives the procedure of the impeachment of a judge of a Supreme Court. Now, to begin the impeachment procedure in the Parliament, a resolution has to be introduced. Now, this resolution has to be introduced either by 100 members of the Lok Sabha or either by 50 members of the Rajya Sabha. Now, after this, a discussion is held in the Parliament, and if the Parliament collectively decides to impeach the judge of the Supreme Court, the resolution has to be supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present in voting. Now, if the resolution has been passed, it has to be presented to the President in the same session for the President's approval. Now, hopefully, up till here, you have understood as to under which article does the impeachment of a Supreme Court judge falls, how a resolution to impeach a Supreme Court judge is introduced, and what are the specific conditions for the impeachment of a Supreme Court judge. So, if a question is asked in your prelims examination, such as which of the following statements are correct, you can answer from the information given in this section. Now we have taken this article from page 14. Now what this article talks about is the difference between electric vehicles and hybrid vehicles. Now this difference becomes important from the perspective of your upcoming prelims examination in the technology section. Now according to this article, the key difference is of fuel between electric vehicles and hybrid vehicles, wherein hybrid vehicles have two sources of fuel, wherein one of them is a battery that powers an electric motor and a normal fuel tank that powers a normal petrol engine, while electric vehicles have only one source of fuel, which is electric. Now, apart from this, the second key difference between electric vehicles and hybrid vehicle is the process of refueling, wherein, according to this article, a hybrid vehicle can be refueled by plugging the car into a wall socket, while in an electric vehicle need to be charged from a charging point. Now, hopefully, up till here, you've understood the two key differences between electric vehicles and hybrid vehicles that have been given in this article. The first key difference is of fuel source, wherein hybrid vehicles use two sources of fuel, which is a battery that powers an electric motor and a fuel tank that powers a normal petrol engine, while an electric vehicle uses one source of fuel, which is electric. The second key difference is of refueling, wherein a hybrid vehicle can be electrically charged through a wall socket, while an electric vehicle need to be charged from a charging station. Now with this, we come to an end in the analysis of today's paper. Now we move on to the question for today.